All right, so we're diving deep into South African civil procedure today.
Sounds intense.
Yeah, we've got all these legal textbooks and court documents and
Oh, wow.
trying to make sense of it all.
Yeah, it can be a bit of a maze, can't it?
It really can.
All those procedures.
Yeah, like a roadmap for navigating the court system in South Africa.
Exactly.
From figuring out which court to even go to all the way to what happens if you actually get a judgment.
Because that's just the beginning sometimes.
Exactly. Winning's only half the battle sometimes.
It really is, you know.
So much more to it.
People often overlook that procedural side of things.
Yeah.
But knowing the rules can be just as important
Right.
as the actual legal arguments.
Absolutely. So let's start with the basics.
Okay.
This study guide we've got,
Yeah.
it breaks down the South African court structure into all these different levels.
Right.
Each with its own specific role. Let's say, hypothetically,
Okay.
you have a minor fender benter.
Okay.
Where would you end up?
Well, that's where understanding jurisdiction comes in.
Right.
It's all about figuring out which court is the right one for your case.
Like which playing field you're on.
Exactly. So for a fender bender,
Yeah.
you'd probably end up in a magistrate's court.
Okay.
They handle those everyday disputes,
Right.
especially when the amounts involved aren't huge.
Makes sense.
Now, let's say your case involves some kind of constitutional issue.
Oh, okay.
Then it's straight to the constitutional court,
Wow. Okay, so that's
the highest court in the land.
top of the chain.
Exactly.
Okay.
And what's fascinating is that each court,
Yeah.
its authority is actually limited.
Oh, really?
Not just geographically,
But-
it's financially, too.
So there are limits
Oh, yeah.
on what each court can handle.
Absolutely.
So jurisdiction is all about figuring out which court is the right arena.
Exactly. The right arena for your case.
Okay.
Now, this study guide,
Yeah.
it uses these terms incola and peregrinus.
I was going to say those sound a little...
They sound a bit like something out of a fantasy novel, right?
Yeah, exactly.
But they're actually all about figuring out where someone is based,
Oh, okay.
which is crucial for jurisdiction.
Right, right.
So think of incola as someone who's a resident of the
Right.
court's area.
Resident.
And peregrinus is someone from outside that area.
Oh, I see. Okay.
And this matters because
Yeah.
let's say you're trying to sue a foreign peregrinus.
Okay.
You might need to attach their property.
What do you mean?
It's like saying to the court, hey, this person may be far away,
Okay.
but they have something valuable here.
Right.
So you have the authority to deal with this case.
So it's like you're grabbing their attention.
Exactly. You're establishing a connection,
Sure.
making sure the court has a firm grasp on the case.
I see. Okay.
Yeah.
So let's say we've figured out the right court.
Okay.
Now, the study guide jumps into this whole thing about pleadings,
Pleadings.
which honestly just sounds...
It's a lot of paperwork, right?
Yeah, a whole lot of back and forth.
It can seem that way.
Yeah.
But pleadings are actually the foundation of your case.
Okay.
It's where you lay out your arguments, your defenses,
So it's like,
setting the rules of engagement.
gotcha.
This back and forth helps narrow down the issues, make sure everyone knows what they're up against.
Right, right.
And sometimes it can even lead to an early resolution.
Oh, really?
Through things like summary judgment, where
Okay.
a judge can make a decision based on the pleadings alone.
So pleadings can actually speed things up.
Absolutely. It's like a legal shortcut.
Interesting.
Yeah, allows the court to bypass a full-blown trial in some cases.
Now, this is where the study guide gets really interesting.
Okay, let's hear it.
It talks about discovery,
Discovery.
being able to demand documents from the other side.
Yeah.
It sounds like legal espionage.
Well, it's all about fairness.
Okay.
Making sure both sides have all the evidence
Right.
before going to trial.
So no surprises.
Exactly. Imagine being blindsided by a document
Oh, yeah.
you had no idea existed.
That would be bad.
It would.
So discovery is like getting all your cards on the table.
It is.
Okay. And what about expert witnesses?
Experts, they're like your secret weapons.
Okay.
They bring specialized knowledge to complex cases.
So like...
Think medical malpractice
Oh,
or
where?
intricate engineering disputes.
Right, right.
Their opinions can really sway the court's decision.
Wow.
They provide insights that the judge might not have on their own.
So they're really important.
They can be crucial.
Okay, so you've got your legal arguments, your evidence, your expert opinions.
Yeah.
Sounds like you're ready for trial.
The final showdown.
Exactly. So the study guide takes us to the trial itself,
Okay.
judgments, and even appeals.
Right.
What exactly goes down in a South African courtroom?
Well, the trial is where all the pieces come together.
Okay.
You present your evidence, question witnesses, make your case before the judge. The judge then weighs the evidence, issues a judgment.
Okay.
But it's not always the end of the road.
What do you mean?
If you think the judge got it wrong,
Yeah.
you can appeal to a higher court.
Oh, okay, so there's a chance for a review.
Exactly. It's like a built-in safety net.
Makes sense.
Yeah.
Okay, but let's say you win your case.
All right.
What happens next?
That's a great question.
How do you actually get what you're owed?
Well, winning the case is just the first step.
Okay.
Enforcing the judgment can involve things like
Yeah.
seizing assets, garnishing wages.
Oh, wow. Okay.
But there are other options, too,
Like what?
like administration orders,
Okay.
where the court helps manage the debtor's finances.
To make sure they actually pay.
Exactly, to ensure fair repayment.
Interesting.
The legal system offers a range of solutions.
So there are options even if...
Even in tough financial situations.
Right.
It's about finding the right tool for the job.
Okay, so enforcement is a whole other
Oh, it's a whole other ballgame.
chapter in this story.
Absolutely.
Wow, we've already covered so much.
I know, right? And we're just getting started.
I know. It's amazing how much goes into this.
It's fascinating.
Yeah, and the study guide really breaks it down.
Step by step.
Makes it so much easier to understand.
Definitely.
All right, well, let's take a quick break,
Sounds good.
and we'll come back and dive even deeper into...
Into the nitty-gritty of South African civil procedure.
Sounds good.
All right. Okay, so let's get back into it.
Yeah, where were we?
Right, so
So African civil procedure.
we were talking about how sometimes winning a case is just the first hurdle.
Totally.
There's so much more to it than just that.
Absolutely. And this study guide we're looking at,
Yeah.
it dives into a lot of different strategies and procedures.
It really does. It's like a whole playbook
It is.
for navigating the legal system.
Okay, so let's talk about some of those strategies.
Okay, sure.
The study guide mentions this thing called settlement offers.
Ah, yes, settlement offers.
Are those like a way to
They're basically...
going to court altogether?
Yeah, you could say that. It's like a legal truce.
Okay.
A way for the parties to find a compromise.
So it's all about negotiation then?
Exactly. It's a chance to save time, money, stress.
Right.
And often leads to a more amicable resolution.
So it's like everyone wins in a way.
In a way, yeah. It's about finding a solution everyone can live with.
And the study guide says these offers can be made at any stage.
That's right, even right before the trial.
Wow, really? So even at the last minute?
Even at the last minute.
Interesting.
Yeah, it's like an escape hatch from the courtroom drama.
I like that, an escape hatch.
And what's interesting is there are different types of settlement offers.
Okay, like what?
Well, you've got your unconditional offers, which are pretty straightforward, take it or leave it. And then there are without prejudice offers.
Without prejudice, what does that mean?
Those are made confidentially.
Okay.
Meaning they can't be used against you in court.
Oh, I see.
If the case actually goes to trial.
So it's like you're testing the waters.
Exactly. You're putting an offer out there.
Right.
But you're not risking any negative consequences.
So without prejudice offers are like a safety net.
Precisely. It encourages open and honest negotiations.
Makes sense.
Parties can put their best foot forward without fearing it'll be held against them later.
But the study guide mentions consequences.
Yes, there's a catch.
For what?
Well, if someone rejects a reasonable without prejudice offer, and then they end up with a worse outcome at trial.
Oh, I see.
They might face some consequences.
Like what kind of consequences?
Well, the court can consider that rejected offer when deciding who pays the legal cost.
Oh, so you could end up paying even more?
You might have to pay your own lawyer's fees.
Right.
And even a portion of the other side's fees.
Wow, that's a pretty strong incentive.
It is. It makes you think twice about rejecting an offer.
Definitely.
So understanding the rules around settlement offers, it's like having an extra tool in your legal toolbox.
Okay, settlement offers, check it out.
Well, the study guide also mentions this thing called security for costs.
Security for costs, what's that all about?
It's a way to protect defendants. Especially when the plaintiff is based outside of South Africa. Or maybe facing financial difficulties.
So if someone's suing you. And they're not even from South Africa.
Yeah, or they might not be able to afford to pay the costs if they lose.
I see, so it's like a guarantee.
Exactly. It's a guarantee that the plaintiff can cover the defendant's legal costs.
If they lose.
If they lose, yeah.
So it's like saying, hey, if you want to sue me, show me you can afford to play the game.
Exactly. It's all about ensuring fairness.
Makes sense?
Making sure the defendant isn't left footing the bill if the plaintiff case doesn't hold up.
Okay, security for costs. Got it.
Got it.
Now let's talk about those pretrial procedures.
Like discovery?
Yeah, discovery and expert evidence.
Right. The study guide spends quite a bit of time on these.
It does. So what are the key takeaways?
Well, discovery is all about lifting the veil, getting a peek behind the curtain of the other side's case.
So it's like...
It involves exchanging documents, answering written questions, sometimes even questioning witnesses under oath.
Wow. Okay, so it's pretty serious.
It is. It's a chance to gather all the information you need to build a strong case.
So you're putting together all the pieces of the puzzle.
Exactly.
Before you even go to trial.
Exactly. And the study guide highlights how important this is to prevent surprises and ensure a fair trial.
Makes sense.
It also forces parties to assess the strength of their case.
Oh, okay.
Sometimes leading to settlements.
Oh, I see.
Or at least narrowing down the issue.
But what if someone tries to hide documents?
Ah, that's called discovery abuse.
Discovery abuse.
And there are consequences for that.
Like what?
Well, you can file a motion to compel the other side
to
comply with the rules.
Right.
And the court can impose penalties.
So there are actual penalties?
Oh, yeah, there are teeth behind these rules.
Wow, okay.
The penalties can range from fines to even preventing certain evidence from being used at trial.
Wow, so it's really important to play by the rules.
It is.
Okay, discovery, check. What about expert evidence?
Right, expert evidence.
The study guide talks about how important experts are.
They are, especially in complex cases.
So how does that all work?
Well, expert witnesses are like specialized advisors to the court.
Okay.
They provide insights on technical or scientific matters.
So if it's a medical malpractice case,
exactly,
you bring in a medical expert.
Right, someone who can explain the complex issue.
To the judge.
To the judge, exactly.
Okay.
And the study guide stresses that there are specific rules.
About expert evidence?
Yeah, both sides have to disclose the identity of their experts. And provide summaries of their opinions in advance.
So everyone knows who the experts are.
Exactly. It allows the other side to prepare their cross-examination and maybe even find their own experts.
So it's like a battle of the experts.
It can be. Each side try to present the most convincing opinion.
And the judge decides who's more persuasive.
Exactly. The judge weighs the evidence and the expert opinions.
Okay, so choosing the right expert is really important.
It is, and presenting their evidence effectively can make all the difference.
Right, all this pretrial preparation.
It's a lot, right?
Sounds pretty intense.
It can be, but it's crucial for a fair trial.
And then the study guide talks about pretrial conferences.
Ah, yes, pretrial conference.
What are those all about?
Those are like a dress rehearsal for the trial. A chance for everyone to get on the same page.
So the parties, the judge...
Everyone, yeah.
Okay.
They identify any outstanding issues.
Right.
And they might even be able to settle the case.
Oh, so it's another chance to avoid trial.
It can be. The judge might really push for a settlement.
Interesting.
Yeah, they might even suggest things like mediation. Where a neutral third party helps facilitate a settlement.
So it's like a more informal way to resolve things.
It can be. It's all about finding common ground.
Okay, so pretrial conferences can be really valuable.
They can. They can save everyone a lot of time and money.
But what happens when a trial is unavoidable?
Well, then it's time for the main event.
The courtroom showdown.
Exactly. And the study guide walks us through all the nitty-gritty of trial procedures.
Okay, take us inside the courtroom.
All right, so a trial in South Africa.
Yep.
It's a very carefully orchestrated process.
I bet.
Each side takes turns presenting evidence, examining witnesses, arguing their points of law.
So it's like a delicate dance.
It is. It's a blend of legal strategy and storytelling.
Interesting. So what happens first?
Well, the trial starts with opening statements.
Opening statements, okay.
Each side gets to outline their case.
So it's like an introduction.
Yeah, like a preview of what's to come.
Okay.
It's their chance to set the stage, introduce the key players,
right,
and present their version of events.
So it's like a legal trailer for the main feature.
Exactly. And the study guide points out that these opening statements should be clear, concise, persuasive, capture the judge's attention.
Right, make a good first impression.
Exactly.
Okay, opening statements, check. What happens next?
Next comes the presentation of evidence.
Evidence, okay.
The plaintiff, who brought the lawsuit, they go first.
Okay.
They have what's called the burden of proof.
Burden of proof? What's that?
It means they have to convince the judge that their version of events is more likely than not to be true.
So they have to prove their case. Exactly. Well, and how do they do that?
Well, they can call witnesses to testify, introduce documents, present physical evidence.
Physical evidence like what?
Like photographs, videos, objects related to the case.
So they're building a case.
Yes, brick by brick.
With all this evidence.
Exactly.
And the defendant gets to challenge all that.
Right, absolutely. After each witness testifies, the defendant's lawyer gets to cross-examine them.
Cross-examine, what does that mean?
It means they can ask tough questions.
Okay.
Test the witness's credibility, try to poke holes in their story.
So it's like a legal tug of war.
You could say that.
Each side try to win over the judge.
Exactly. And the study guide emphasizes the importance of thorough preparation and strategic questioning during cross-examination.
So it's not just about asking any questions.
No, it's about asking the right questions.
Right, the ones that will help your case.
Exactly.
Okay, and once the plaintiff is done.
Right, once the plaintiff rests their case.
Then it's the defendant's turn.
That's right. The defendant presents their own evidence.
Okay.
They call their own witnesses, introduce their own documents.
So they present their side of the story.
Exactly. They might try to rebut the plaintiff's evidence.
Rebut?
Yeah, like contradict it, offer a different interpretation.
Okay.
Or raise legal defenses.
Legal defenses? Like what?
Like things that could defeat the plaintiff's claims.
Oh, I see.
So the defendant's presentation is just as important.
Right. They have to be just as convincing.
Absolutely.
So it's back and forth, back and forth.
It is. It's a battle of persuasion.
And the judge is the referee.
Exactly. The judge considers all the evidence and arguments.
Right.
And then makes a decision.
Okay, so both sides have presented their case.
Yep.
All the evidence is in.
Right.
What happens now?
Then each side gets to make closing arguments.
Closing arguments. Okay.
This is their last chance to summarize everything.
So that's the grand finale.
It is. It's their final plea to the judge.
To rule in their favor.
Exactly. They remind the judge of the strengths of their case.
Right.
Point out the weaknesses in the other side's case.
Okay.
And try to leave a lasting impression.
So it's all about persuasion again.
It is. It's about making a compelling final argument.
And then what? The judge goes off to make a decision.
That's right. The judge considers
all the evidence, all the arguments.
Yep.
And then issues a judgment.
Exactly.
And what kind of judgments are there?
Well, they're of various types.
Like what?
The judge might rule entirely in favor of one side.
Okay.
Or find that both sides were partially at fault.
Oh, I see.
They can award damages.
Damages.
Issue injunctions. Order specific performance.
Right, so there's a whole range of possibilities.
There is. The judge has a lot of flexibility.
In crafting the judgment.
Exactly. It depends on the specific circumstances of the case.
Okay, so the judge makes a decision.
Mm-hmm.
And that's it. Case closed.
Well, not necessarily. There's this thing called an appeal.
Appeal, right?
If a party thinks the judge made a mistake,
okay,
they can appeal to a higher court.
So it's like a second chance.
Yeah, a way to make sure the judgment was fair.
Right, to double-check everything.
Exactly, and the study guide goes into detail.
About appeals?
Yeah, about the whole appeals process.
Okay, so appeals, judgments...
Enforcement.
Right, enforcement.
It's like the legal battle continues.
Even after the trial's over.
It can. Sometimes it takes a while to really resolve things.
And speaking of enforcement...
Yeah.
What happens when someone wins their case?
Mm-hmm.
But the other party just refuses to pay?
That's a tricky situation.
It is. What good is a judgment if you can't collect?
Exactly. A judgment's just a piece of paper.
Right, if it's not enforced.
So the study guide talks about things like writs of execution.
Writs of execution.
Garnishing wages.
What are those?
Those are some of the tools the court can use to enforce judgment.
So they're not messing around?
Nope. They have ways to make sure people comply.
So a writ of execution, what's that?
That's basically an order from the court.
Okay.
That allows the sheriff to seize assets.
Seize assets, you mean like...
Like property, belongings.
Oh, wow.
And sell them to satisfy the debt.
So it's like the legal version of repossessing something.
You could say that, yeah.
And garnishing wages? What's that?
That's where the court orders.
Yeah.
A portion of the loser's salary to be deducted and paid directly to the winner.
So it's like a forced saving plan.
It is. A way to ensure they eventually pay up.
Wow, those are some serious consequences.
They are. The court has the power to make sure justice is served.
Makes sense. Okay, so the study guide also mentions some specialized procedures.
Oh, right. There are a few more things.
Yeah, like things that add another layer of complexity.
To South African civil procedure.
Okay, so what kind of situations are we talking about here?
Well, imagine you have a case with multiple parties involved.
Okay.
All with interconnected claims.
So it's a complicated case.
Yeah, lots of moving parts.
Okay.
That's where joinder comes in.
Joinder, what's that?
It's a way for the court to handle these multiplayer lawsuits.
So everyone's in the same courtroom.
Exactly. It prevents multiple lawsuits on the same issues.
Saves a lot of time and hassle.
It streamlines the whole process.
Okay, so joinder's like a legal team-up.
You could say that, yeah.
And what about those times when you need to act fast?
Ah, you're talking about urgent applications.
Urgent applications, right. The study guide mentions those.
Yeah, those are for situations where waiting could cause irreparable damage.
Okay, so it's like an emergency button.
It is. You need the court to intervene quickly.
Like when?
Like someone's about to demolish a historic landmark.
Oh, wow.
Or publish damaging information about you.
So you need a court order to stop them.
Exactly. And these urgent applications, they can be brought on very short notice.
Okay.
And the court can make a decision quickly.
So speed is key.
It is. Sometimes you need a resolution fast.
Okay, urgent applications. Got it.
Got it.
Now, the study guide also mentions something called...
Anton Pillar order.
Anton Pillar order, yeah.
That's a very specific type of order.
What is it?
It's essentially a search and seizure operation.
Okay.
Authorized by the court.
So you're talking about a legal raid?
Yeah, pretty much.
Wow. Okay, when would you use that?
When you suspect the other side is hiding evidence.
Oh, I see.
And you need to seize it before they can destroy it.
So it's like you're catching them red-handed.
In a way, yeah.
But the study guide says there are strict rules.
Oh, yeah, it's not something you can use lightly.
Right, you need strong evidence.
Exactly, you have to convince the court it's necessary.
Okay, so Anton Pillar orders are a powerful tool.
They are, but they're used sparingly.
Makes sense. And what about when someone owes you money?
And they're not paying up?
Yeah, the study guide mentions a special procedure.
Oh, you're talking about the provisional sentence summons?
Provisional sentence summons. That's a mouthful.
It is, but it's basically a faster way
to
get a judgment when your claim is based on a liquid document.
Liquid document, what's that?
It's something that clearly shows an unconditional debt.
Like a signed contract or something?
Exactly, like an acknowledgement of debt.
Okay.
So this procedure streamlines the process.
So you can get your money back faster.
Exactly. It puts pressure on the debtor to pay
or to present a valid defense.
Right, they can't just ignore it.
So it's like a shortcut to debt collection.
In a way, yeah, but there are still rules to ensure fairness.
Of course. Okay. Wow, this has been an incredible journey.
I know, right? We've covered so much ground.
We have, from choosing the right court to all these specialized procedures.
It's amazing how much goes into South African civil procedure.
It is, and this study guide has been so helpful.
It really has. It was a great resource.
If anyone's ever facing a legal challenge in South Africa, understanding the procedures is so important.
It is. It can make all the difference.
Do your research, seek expert advice,
and approach each challenge strategically.
Absolutely. Well, that wraps up our deep dive
into the fascinating world of South African civil procedure.
We hope you've enjoyed it.
We'll be back next time with another deep dive
into the legal world.
Until then, stay curious and stay informed.
Thanks for joining us.